College Worksession-AO just send it together. AO 2015-150. Go right, identify ourselves for the record. We're on tape, by the way, or recording, however they're calling it these days.
Brian Robbins, Municipal Assessor.
Dennis Wheeler, Municipal Attorney.
Patrick Flynn. Ernie Hall.
Bill Evans.
Elder Johnson.
Amy Kembowski.
Dick Trainee. Dennis, we'll turn the time over to you.
Thank you, Mr. Chairman. I handed out a document. It is essentially labeled on its face the same as the AO that's currently before you. This one, however, I made a few little markups starting on page 2, so I was going to just kind of walk through those and see what kind of questions they generate. Keeping in mind that Ms. Tucker and I just talked briefly this morning about some of these things, and there's questions we have in our own mind about how to address these issues. So this is just for discussion. It's not, at this point, an S version. If we decide that an S version is appropriate, we'll work on that and have it ready for you in time for debate and discussion. So the first issue that I wanted to address at the bottom of page 2, the paragraph there, lines 40, 42, talks about charter school space that is owned or under lease or rental. The state statute provides an optional exemption for charter schools that are using property that's leased or rented. It doesn't speak to owned. So the question is whether or not we should have an exemption built in here for property that's owned by the school versus rented or leased. It's outside the scope, I think, of this current legislation. It may be an appropriate exemption that's dealt with already in other state statutes. Maybe Mr. Robbins could speak to that. But that was kind of a question. If there is an exemption that's specifically available to charter school property that's owned by that school, maybe that needs to be addressed separately so there's no confusion about it.
Mr. Flynn, sir.
Maybe a question for Wilkes-Barre. Are you guys a registered nonprofit?
Not the APC. The APC. I'm giving Kolanowski. I'm the chair of the Wilkes-Barre APC. So we are a statutory board, lowest level government, if you will, in the statute. That we are the governing board, the mini school board, if you will. We have 2 nonprofits at our school. We have a PTO that's nonprofit, it's a 501c3, and also our real estate arm, which Mr. Ledford next to us is representing. They are also a nonprofit 501c3. To this specific point, we
I don't think it would be an issue.
But to the specific point here, charter schools cannot own their facilities. The APC proper cannot own their facility. It has to be done eventually. When we go and buy, it will have to be through a nonprofit arm of our school.
So, Jeff, your organization can own it.
And lease it. So I don't think it would be an issue because you can't own a facility.
Okay. Thank you for that clarification.
Mr. Hall, sir.
I was going to wait till we got all the way through this, but I have got some confusions going on in that same way, and I guess it's as good a place as any to discuss them. I'm confused by. Let me start by saying I support what we're doing here, but I want to make sure I understand what we're doing.
Tell them you don't like it. It's more fun.
We've got the school district here, and we've got charter schools, and I'm not sure any of us totally understand how all of this works. But what I do know is with the Anchorage School District, the municipality of Anchorage, if we acquire a property, it's a vote of the people that says, okay, we're going to accept the liability, we're buying a piece of property, and they understand that up front. The charter schools are part of ASDs. But what I'm understanding is the ownership of the building is going to be by a nonprofit or a corporation that's not actually the charter school. But we're entering into a 20-year agreement with a property owner that if we get into that 10 years and the charter school decides we're not going to be here anymore, is there going to be any liability to the public? Because if I understand right, the payment's going to be made with part of the Education Foundation formula that comes to you through the school district. So it's public money that's actually being used to make the payment. I understand it's passing through another entity here, but does this string ever come back to the public, the fact that 10 years in or 5 years in, the school dissolves?
Can I answer?
And then, after you, Amy, then Tim. Go ahead, Amy.
My understanding, correct me if I'm wrong, Wheeler, my understanding is under subsection F, if there's any change in the status of the charter school or anything, because that's what you're saying, is like the charter dissolves, right?
Right.
I think if there's any change in that, then that exemption would no longer be applicable, right?
I'm not talking about the exemption, I'm talking about the liability of the lease or the liability of the building.
So the
I
way,
understand the exemption would go away when the school no longer occupied, but if I'm a landowner and I've entered into a 20-year lease that part of the school district and all of a sudden they say we're not going to be here anymore, I don't know that I would just measure with it. That's fine, I understand and you can leave. That's what I'm trying to get.
I would think that's
through
terminated.
the chair, Mr. Hall, the answer is, as far as I can tell, no. There is no obligation for ASD or the Muni to cover that lease if there's not a qualifying charter school using that space. If the charter school closes for whatever reason, there's a lease there, that responsibility is the charter schools alone.
Actually, it's not the charter school, it's the corporation or the nonprofit.
Whichever corporation signs the lease or signs the rental agreement.
So the charter school may go away, but the
I'm gonna go to Mr.
liability to
Steele.
the individual instead of entering the lease would still.
That's right. The charter school is not going to have legal authority to pledge ASD funds year to year in that manner.
Mr. Steele.
Yeah, charter schools are set up under contract to the school district, and I believe the contract is only 10 years long. And so it wouldn't be 20 years, first off, but the way they are working, the way that especially the larger charter schools are working, they are setting up nonprofits or corporations, benefactors, if you will, some of them, to work all this stuff through. And I don't believe that first off, the tax exemption goes year to year. And so January 1st, or something like that, it said in what I read, it has to be validated for the assessor that it's still in, they're there and they're still in place. But if they back out of it, it's not the school district's liability. It's,
Yeah.
it's
That's all I was trying to get clear. I understand the tax exemption. It's got to be occupied by a charter school to be able to get it. I was just concerned about, I know what happens when the school district builds a school, and I understand what happens when we do it, and you're making an obligation. I just want to make sure there's a clear delineation that if in 5 years the school's not there, that liability doesn't come back. So it sounds to me like it's squarely on the shoulders of the parents that have formed the corporation or a nonprofit that in fact owns or is leasing the property or owns the property. That's what you just told me.
I would be careful about saying it's on the shoulder of the parents. It's the obligation of the corporate entity that signs
Right.
the lease.
Right, yeah.
Why don't we go to Mr. Evans? Mr. Evans, sir.
Yeah, a different concern I had in this, Dennis, was I just don't understand how we ensure that this benefit that we're conveying through the exemption is passed along to the charter school and not absorbed by the landlord.
We're going to get to that in 2 more steps here.
Anything else? Okay, Mr. Witter, please.
So we'll get to that in just a second. The next issue is at the top of page 3, line 1, the word entire. So the application under this code provision requires that the lease or the school show that it's going to have exclusive use during the entire exemption year. The question for you is, what happens in, say for example, the summertime? If the school space is used for some other purpose during the summer, are you saying that we should deny the application? Because it's clear in the face that the school is leasing through May and then picking up again in August. But in that mall, in that space, it's going to be a t-shirt shop in the summer. Or maybe the school is going to use it to run summer camps to raise money, but those summer camps aren't necessarily school student functions, if you will. So I was concerned about what that meant in terms of being able to tell the property appraisal office whether it's a qualifying lease or not.
Questions from assembly members?
I would like to direct a question to Rick Shula, if I could.
Go ahead, ma'am.
Do you see this being an issue if we take out entire and just change it to the exemption year, meaning the school year instead of?
I think it would be very helpful if we would have the ability to lease the gym for X amount of dollars, or a summer school program. There's a Babylon summer camp, a language immersion program that is looking for a place to stay. We're not talking about making a lot of money, but it would be helpful to keep up with maintenance. So it would, maybe you could put it so it's not X percent of, you could do a percent, so you're not, in our world, we would like to be able to sublease it or have some income coming in when it's not being used. Now, it would not be substantial, but it would be helpful for us to have some income coming in.
We would like the same option that ASD proper has, where whether a church leases or rents for a time or an activity's there, that I think that is definitely very critical for us. I think earlier the point that was raised by Mr. Hall and commented on here by the municipal attorney. In an ideal world, ASD would have built charter schools where they all were in district facilities. Would make this a whole lot easier for all of us involved. However, that's not a reality today. And as charter schools have evolved as they have, the district with us, with RILCA, has decided to take a much more engaged approach as we go forward because of our tight budgets across the board. So in our new lease requirements, this came out of JDO and the district's legal firm, of being indemnified both as the district, the school board, and the APC proper if the school were to cancel. So now this is going to be the standard for all charter schools going forth with leases.
So, just to follow up, so Rick Shula, I haven't read your lease, so forgive me, but Rick Shula, you guys, though you might be in school for a typical school year, you lease the facility for the whole year. So essentially, as a charter school, as an ASD charter school, you're still paying for the facility for the entire year, regardless of when you're in session.
Right, correct.
Okay. With that, I think it'll be helpful for me to talk to the other sponsors of this before I support this particular amendment or potential change. But
And the other scenario is different because to the extent that they have exclusive use and they sublet or sub-rent underneath that, that's one thing. The other scenario is where they only have exclusive use January to May, August to December. They don't have exclusive use in the summer. What is the will of the body at that point?
Sure. I
Should
see what
they,
you're saying.
because he's going to be looking at the exemption as of January 1, but he's going to get a document that says there's a break, if you will, in exclusivity. Is that a problem? I don't know if you have any comments about it.
Well, I agree. It's something we've discussed and wondered about, so we would like clarity.
And the facility would be used year-round because you have all the infrastructure inside, you got all the materials, so if that is not covered, we'd have to find storage.
No, your example is the first, which is you've got, it's a building that's really yours for the whole year, but other schools that are in different space may have different programs set up, where maybe they don't have exclusive use in the summer. You could require that be clear in their lease, or you could make some exception for that scenario, but we need clarity so he knows what he's doing when he gets an application.
Mr. Steele, sir.
It's like a sublease, I think, in terms of, they have it for the whole year, and if they lease out their gym for daycare or some other activity, it's kind of like the school district leasing out the auditorium at West High School for a function or something like that. And so you're going to get into a nightmare if you're having breaks and that.
Well, and what I'm
and
saying is that that's only one of two scenarios. The sublease scenario is one. The other is where they don't
have
have
to
it.
move out.
Sure, they put their books and chairs away and somebody else is using that space in the summer.
It's going to be a nightmare for the assessor.
Ms. Tucker.
Yeah, just for clarity purposes, in the sort of list of charter schools that I believe they furnished you and you passed on to me, we have an Alaska Native charter school, we have Highland Tech, we have Family Partnership, we have Frontier Charter, Eagle Academy, Winterberry, and Ricochet. And there may be one more coming on line with the school district, and some of them have small space in a big building that's used for something else, and it's just office and administrative space. So that might only be for 9 months. So then does the landlord of that office building have the exemption for the whole year? And if he does, then when Mr. Wheeler gets to the other question of how the pass-through is shown, then maybe that will work itself out, because as long as the whole value of the exemption is a pass-through to the 9-month or 12-month use, then you may be okay. So I just wanted to clarify that.
Any questions from assembly members? If not, Mr. Wheeler, please continue.
Sir, the next issue is the one that Mr. Evans was getting to, and that starts at line 6, that full paragraph there, talks about how to make sure that the school gets the benefit of the exemption. And this particularly concerns the assessor, because to administer this and try to analyze whether or not they're getting the full value is pretty tricky. Ideally, the leases and rental agreements will be passed through. That is, the clause says if there's any taxes, property taxes, they're passed through to the school. If there's an exemption, there's nothing to pass through. If there's no exemption, then obviously there's a pass-through and they're not qualified. In that way, when he gets the application, January 1, he can see there's a paragraph that provides for pass-through, that the taxes are not buried somewhere in the rental rate. Without that, then it becomes very difficult to look at a rental rate and figure out how you're going to parse out what's fair market value versus what's fair market value plus taxes. He's far more qualified to speak to this issue than I am, but it's an area of concern. You want to add on to that?
I think you covered it pretty well, but our concern is that lease rates fall within a range. And especially when you're talking about specialized property, like classroom space, for example, market rates are not easily available. So to analyze the lease and state unequivocally that this represents a pass-through to the school would be very difficult for anyone to do. Even if you hired a fee appraiser, they could give you an opinion, but to state unequivocally that this represents a market transaction less net of taxes would be a subjective exercise. So if there were a requirement that the lease be structured to pass through the taxes, you would still have to assume that the charter school acted in their own best interest and negotiated a fair market lease, but at least you could see that once the exemption is in place, no taxes are passed through to the charter school.
Mr. Evans, sir.
Yeah, and I've been thinking a great deal about that same issue, because it's sort of out there in the free market and the landlord can adjust the rent up to make it look like it's getting passed through and it really isn't. Is there not a mechanism whereby instead of necessarily an exemption here, we calculate the money of the property tax that is accredited to the school space and then collect it from the property owner and give it back directly to the charter school?
You know, that involves an analysis to determine that amount, right? Which we may have to do in
We'd have to do anyway.
space anyway. But then we've got to collect it. If we can't collect it, then
We'll be collecting it normally, and unless we pass this, we collect it anyway.
and then we deal with the appeals. In terms of simplicity, in terms of administration, I think if you have the application produce a lease that's a pass-through or a rental agreement that's a pass-through, it's a whole lot easier for everyone.
Easier, sure, but you do have the risk that any, landlord that wants to, because whatever the charter school can pay, I mean, normally property taxes for a renter is factored in there. All the landlord has to do is say, okay, I have to come up with a lease that says these are the property taxes on this portion of the building that the charter school is responsible for, but I'm also basically going to raise the rent an amount, either completely that much or some percentage of that, so the charter school really doesn't get the benefit if you have an unscrupulous landlord or somebody who's maximizing their profit, unless we do it some other way. But for a lot of the cases, they probably would get some benefit, but I definitely see under this scenario, you could be benefiting landlords more than charter schools. That's all.
Ms. Dombrowski?
I know this came up at the assembly meeting, so, and I knew there was at least one charter school that said the rent or the tax amount it was kept budgeted separately, and so there was a way for the charter schools to differentiate, this is how much goes to property taxes. Can you speak to that?
I'll just read this paragraph really quick. This is the lease that Worksession is going to sign. This is Article 11.1. Payment by leasee. Taxes. Leasee will pay to the appropriate governmental body all actual real property taxes and assessments for the leased premises. In the event taxes are assessed for periods when leasee did not occupy the leased premises or have full use of the leased premises per Article 10, leasee will pay a prorated portion of the taxes and assessments, if any, relating to the occupancy of the premises. Leasee shall be liable for 100% of any property tax increases during its occupancy of leased premises. So that's in our lease, that's where taxes are discussed, and it's put squarely on the shoulders of Worksession.
And that's the kind of clause we're talking about. If that's on its face in the documents, then we're done. It's really easy.
It's really easy, but the reality is if I'm a landlord and I have a tenant, charter school, or anybody else, they can afford to pay so much for my property. I could put that clause in the lease that says they're responsible for the taxes. The city exempts them so they don't have to pay that much. I as landlord know that. I can increase the value of my rent because they have more money now to pay me. That's all I'm saying. And maybe there's no way around that and we just have to hope for the best. But that's why I was thinking if there is another mechanism whereby it may be a little more complicated, but if we could actually collect the money and give it directly to the charter school in the exact same amount that would have been exempted, it eliminates that problem. I want to help the charter school.
I believe that's what the Matsu Valley is doing, something similar to that. And I could see a couple benefits. It's directly back. The other problem is theoretically we'd have to pay, and you're kind of fronting the money. It's just a cash flow deal for 1 year. And then what happens if the landlord doesn't pay? Would that affect your budget? I mean, for us, it's kind of 6 in one, half a dozen the other. I definitely appreciate what you're saying. Hopefully we can negotiate a strong deal, but quite frankly, charter schools typically, hopefully they got a student body a parent body that is good at negotiating leases, because we're not in the business of negotiating leases every day. But I think we feel pretty confident in the way this lease is structured that we're protected going forward. You're right, you could kind of split the difference, I guess, and share the value.
And I think this is the standard that the district procurement shop is using from here on out. So long as Anchorage has charter schools in this district, this is the model that it'll be used on.
Yeah, this language will be in any charter schools lease going forward.
No charter school can go into multi-year obligations without it going through ASD procurement. Even though our contracts with the school board proper, they defer to the CFO and procurement. So all of us going forward, whether you're existing or coming down the stream, have to follow this model from now on.
Ms. Gray Jackson.
Thank you, Mr. Chairman. Obviously, I really want to see this work. And so I really like Mr. Evans' suggestion in terms of, collecting and then reimbursement. But I'd like to hear from Mr. Robbins. What's your thoughts, number one, on his suggestion? Number two, which method is going to work best for you and your staff? Thank you, Mr. Chairman.
Thank you. I think from our perspective, we could do it either way. It would be, we're estimating the exemption amount either way. So whether we do it on the front end or the back end, I don't think would be impossible for us. If we're doing a refund every year, that would be an annual process that we would have to do. Whereas if we have an exemption, the way the language is currently written, we wouldn't have to do that every year, only when the lease is expired or something changes within the lease. So there would be a little more work on the collection and refund. Now, this is also a question for Treasury, because they would actually have to administer the collection and refund process. And I can't really speak to that, the difficulty of doing that within their system.
Thank you.
Other questions? Assembly members. Mr. Wheeler?
Next issue is at lines 15 through 18 in terms of calculating the exempt space, if you will, on a proportional basis. What does proportional basis mean? Talking with my attorney who handles a lot of the property tax issues, her suggestion was to modify this to focus on square footage, because that's the proportionality that's most commonly used by the assessor's office. Brian, can you speak to that?
Yeah, and I would agree with that. If we based it on square footage, that takes any ambiguity out of it.
I would concur with that.
Any other questions from some of the members? Mr. Evans? I'm sorry. You know me. Mr. Wheeler?
Mr. Chairman, that's it for my comments as to this AO.
Mr. Evans, any questions? Mr. Dombrowski?
No, I think Mr. Wheeler and Mr. Robbins bring up some good points, and I think everybody wants to get it right. So I think we'll have to think about this on some of these points, but for the most part, I think we're getting closer.
Mr. Hall, you had a lot of questions.
I do have one other question here. We had a summary of economic effects for this for $113,000. Is that one school or is that 8 schools?
That's all schools that aren't already exempt. And it did not assume the German school would be moving into a new building. I've run some new numbers with that assumption starting in 2016. Moving into a new building valued at $12 million. The exempted taxes over the total period would go from $715,000 to $1.5 million, round numbers. So the $12 million additional value would make a big difference. Now, we also have one school that doesn't currently have a location. So if they move into leased property, then you're going to have an increase in the effect of the exemption. I wasn't aware that they can't actually own a building, but if the nonprofit owns the building, then it won't have any effect. You could use, you can run numbers based on your own assumptions at about $150,000 per million in value. We talked to all this, I think we talked to all but one of the schools, and this most recent scenario was based on information they gave us. A couple of other schools might be interested in moving, but they don't know where, they don't know how, they don't know when. So we left those status quo. Some of the schools are in buildings where they only occupy a portion of the building, so we've done that on a proportional basis in our calculations.
Can you restate for me the yearly potential tax exemption for the new building? I think you stated it over the term of the lease. I couldn't hear you.
Okay.
You're kind of quiet.
I'm sorry.
That's okay.
I'm not understanding the question.
How much
What's
do you
the annual exemption?
Oh, the annual exemption, I have it by year for the 5-year period. And would you like it, assuming the Rilke-Schuler? Okay.
Yeah.
Okay, in 2014, it would be $110,554.
That's all schools, right?
That's all schools. 2015 would be $113,871.
That's all schools.
That's all schools. In 2016, we assume that the $12 million building comes in, and that's $297,047. 2017, $305,958. 2018, $315,137. 2019, $324,591. And this assumes no change in mill rate, but a 3% increase per year in assessed value.
Can you send us that?
I can.
Thank you.
Mr. Jackson?
Thank you, Mr. Chairman. Just to follow up, when you were talking about the new building, valued at $12 million, and then you said something about, but their portion will be $715,000 to $1.5 million. You're talking about the assessed value portion, correct?
I'm sorry, I must have said something that didn't come across clearly. I said, if you wanted to make a different assumption, if you wanted to consider that this school that doesn't have a property would have a property, you can make assumptions based on about $150,000 of tax value per $1 million of assessed value, just a rule of thumb.
Okay, let me back up, if I may, Mr. Chairman. You specifically, and I just want clarity, okay? You talked about the new building for, I can't pronounce it. Rilke-Schuler, thank you. Rilke-Schuler, okay. Assessed value being $12 million, and I thought I heard you mention a number, $715,000 to $1.5 million, and I think that you're talking about the assessed value there, right?
No.
Okay.
Okay.
So what are you talking
I'm
about?
talking about tax value, the taxes, the amount of taxes over the 5-year period. Without the $12 million school, if we estimated that amount at $715,000. With the $12 million school coming online in 2016, that tax amount over the 5-year period jumps to $1.5 million.
For the entire building.
For the all schools over the 5-year period.
In other words, the total amount of tax that would be avoided in 5 years, over
For
5
all
years is
schools.
1.5. For all schools, it would be 1.5.
Okay, I get it, because I thought that you were talking about assessed value, and I ran some numbers on taxes that, on the assessed values, and I'm like, so anyway.
Yeah,
Okay.
and I need to correct myself. I said 150,000. I meant 15,000 per $1 million.
Thank you.
Okay, sorry about that.
That's okay, thank you, Mr. Chair.
Mr. Steele and Mr. Hall.
You're talking all schools. So you're figuring the space that they currently have. And I mean, some of the schools are currently, well, at least Aquarian is in an ASD facility that they rent basically from ASD, or there's an arrangement. I don't know what you meant by all schools. A
This
family
has been
partnership-
premised on what we know today, the schools that would be eligible for the exemption, making some assumptions. This is the total cost over 5 years.
Whether
Obviously,
they're planning to move into a different facility or not.
that would all change this, yeah.
And
Schools can
the
close,
other
schools
thing
can
is
open.
the stream school, did you include that or not?
I don't think so, because
Okay.
it's conceptual.
Right. And we've,
Yeah, okay. I just was trying to clarify that.
Any other questions?
I don't believe so. I have a bit of a concern about the homeschool charter schools, and I know they have office space, and so I suspect that office space would be appropriate. And I know Frontier has some testing space there too, but they're homeschools. Yeah.
Yes, Mr. Ritter.
That's a perfect segue to something I forgot to mention, and Ms. Tucker pointed out to me. On page 3, line 4, the proposal is that only charter schools with an enrollment of 50 or more students would be eligible for the exemption. I can't find a provision in state statute that has that limitation. My concern is whether or not we can put this kind of limitation in place. Typically, the way I understand the way we work on exemptions is once we decide to take on an optional exemption, we need to conform to the state statutory requirements, including eligibility. If the state statute does not put a restriction on eligibility, my legal assumption is that every charter school is eligible for the exemption, assuming they otherwise qualify. That raises the issue about whether the home schools are treated as charter schools for provision of the tax exemption. I don't think it's anybody's intent that somebody who is homeschooled or has a homeschool in terms of the traditional way we think of it would all of a sudden find that they have a tax exemption for their home, for their house, right? So Julie and I just briefly discussed this. We probably should do a little bit of work on that to figure out what, this was a suggestion from somebody who was promoting us taking on the exemption, but I don't know what the legal authority is to provide that kind of a threshold.
Well, these two schools have office space. They have a headquarters, if you will, and then they work with their homeschool parents all over wherever they may be. But
that begs the question as to whether that office space would be qualifying under the charter school tax exemption program.
I've got Mr. Hall, I've got Julia, and I've got Mr. Bowser.
Something that would really help me with this, and I think we're all confused by what we're talking about here, is if the school district could give to us a list of each one of these schools, where they're located, and why there's no taxes on them now, and then get an idea of the ones that would be tax exempt. That's where my confusion is here.
Right.
I think I have that information. I could provide it for you.
That would really help me, because that's where I am. I see 8 schools, apparently we've only got, what, 2 that might be eligible for exemptions, if I'm understanding? 1 now and 1 may be coming on in the future?
No, I don't believe that's correct. We have potentially 5 that, and well, potentially 6 that could be eligible for exemption. 3 are already exempt.
Okay. And of those 6, then what you're telling me is the summary of economic effect says that's $113,000 in tax for the 6 that would be exempt
Per year.
per year.
Right.
Okay.
Ms. Dombrowski and then
Can you go Julia
Ms. Tucker?
first? She might answer my question.
Okay, I guess two things. One is that that as I understood it doing this, sometimes a school, and I think Frontier Charter was mentioned, it has a small office and no dedicated classroom space. And so when I went through the materials that were available to me online with the school district, it seemed to me that the school itself had enrollment that supported the small office, so that the small office, even if it was in a retail mall, would potentially, under this ordinance, under the state ordinance, could qualify. Then on the question about the 50, the state and Mr. Wheeler and I, as he said, we need to look at this, more. But the statute says a municipality may by ordinance classify and exempt or partially exempt from taxation. So I took it in a broad sense about classifying, that the classification for the tax exemption could be at 50 as suggested in paperwork that I received from the sponsors, or at some other number. But that way, because I couldn't figure out the relationship of the home schools, except those that are under an umbrella of one of the charter schools, and we didn't want to do that. So that's why he and I are going to look at that, because my interpretation of the classification part may not comport with how we do tax exemptions.
I think actually she touched upon what I was going to say, but I will take my questions offline with legal.
Anything else, Mr. Wheeler?
No, sir, thank you.
Questions from assembly members? Mr. Klein, do you have a question that you ever wanted to ask yet?
I've got all my answers.
Okay, sir. Mr. Hall? Mr. Dombrowski? Mr. Evans, sir? Mr. Steele?
Whatever you know.
Mr. Graham Jackson?
Thank you, Mr. Chairman. Well, what I'd like to be known right now, in terms of the folks who are waiting for us to do this, what's the status? What are our thoughts on approving this on Tuesday? So that people know, ahead of time, if we can answer that question now.
I don't think we can answer that right now. I think what we're going to have are some questions going to our attorneys to see how we can have an S version crafted. I think it's been very useful as we tried to isolate what type of schools we're talking about and the cost. It's really helpful getting the cost factor down in this exemption. I don't know. We'll see where we're at on Tuesday.
Right. And I guess to follow up, there are quite a few changes that need to be made and conversations that need to be had. Today is Friday. And that's the only reason why I'm bringing it up. Just kind of give folks an idea of where we might or may not be on Tuesday. But, if we can't answer that question right now,
We can answer it
understood.
right now.
Thank you, Mr. Chairman.
Mr.
Steele?
Chairman, my understanding is, of course, that this wouldn't be available until 2016.
Yeah.
So, I'm sorry.
So we got the time to look at this and get it right.
Right.
I don't want to pass something that's wrong before we
Right.
get go.
My point.
It would be nice if you could find out from the state the legality of the 50 or more question.
Yes, sir. Hopefully, we'll find in the Senate, House journals, and in the minutes, whatever you want to call it, we'll find expressions by sponsors and so forth that talk about the language that she described, the partial.
Mr. Wheeler,
what is
you and
partial.
Ms. Tucker could get together and figure that out. We'd appreciate that because that's something we need to have answered. How many numbers are we talking about?
I think Mr. Linford has a comment on that.
I think it might be a simple resolution, and Gibby maybe speak to this. If the name is charter school, I don't think anybody can be a charter school. I think it is a laborious process to become a charter school. And so that whole provision might be able to go away, the 50 number. I just threw that out there because I was trying to come up with my own simple mind, how do you not have an individual homeschool kid get that? But if it's a charter school, I think you have to go through the state to get that provision, and in that case, it's probably going to be a moot point.
It's a nice for the school district, the charter school too.
I believe.
Right, it's a moot point because 278 changed that last year. In order to establish a charter school, you have to have a minimum number of students, which is 50, then it escalates over the next couple of years.
That's a provision in the statute.
In 278, HB,
All right.
changed that way.
I couldn't find it. I couldn't find it in this thing.
It makes sense.
Yeah.
Great. I'll,
Yeah, we talked with the sponsors on this when we were looking and trying to figure out strategy of how to approach this.
Let's end this work session. It gives us about 20 minutes before another work session starts on marijuana. Yay. That's going to be a fun one. This work session's over with.